Okay. Lebowski. Lebowski, you good? Thank you, sir. Okay, how's everyone doing? Good. Everyone have a nice day so far? Okay. Has everyone gotten the email about how to download the exam software? Everyone got it. Has anyone had any difficulty doing so? You've done this, what, several times before? Okay. So the format for the midterm I've discussed more times than I can count, but one thing to just know, if for whatever reason your computer breaks during the exam, get a blue book, okay? Unfortunately, we do not have any sort of IT support at the school. We don't have it. It doesn't exist. So if you have difficulty, your computer crashed or whatever, your best bet is just take out a blue book and start writing. That will not be a reason why you failed the exam, okay? If you actually have computer difficulty, I will read what you write, and that will not be a deterrent, but it happens every year that 1 or 2 people have computer difficulties without fail, and they usually do just fine, okay? In terms of the format, try and get here a few minutes early. My Langdell, Garrett will be here. You know who he is. He's a nice guy. I already warned him, don't ask him any questions. People try this. Don't ask him any substantive questions. He will not be able to answer them, nor should he answer them, okay? You have 90 minutes. I don't think it will take that long. I don't think any of you will need 90 minutes, but you're welcome to take the full amount of time that you have. Any last minute questions about the exam? Anything in your mind? Okay. No questions. All right. Well, good luck, because I will not be here on Monday, but I wish all of you the best of luck. I will try to grade them as expeditiously as possible. Students don't always understand grading is extremely time consuming. It takes me 30 minutes per paper, so you can do the math how long that takes to read. I don't rush through them. I actually read them carefully. If you want to come talk with me afterwards, which I encourage, you should do that. If your grade is on the lower end of the spectrum, like C or lower, you should probably come talk to me, because maybe there's something you're doing wrong that we can correct midstream. Again, the purpose of this midterm is not to scare you. It's to give you a wake-up call and say, uh-oh, I'm doing something wrong, or I'm doing something right. Let's keep doing the same thing. And I hope this works out well, and you guys kind of skated by, but in the future, virtually every single 1L class will have this, so you somewhat evaded it, but hopefully it'll be productive for the future. Okay. All right. Any other questions on the midterm, on the schedule, anything else? No? Okay. Let's start off with review. I explained last time that the most difficult aspect of this entire topic is terminology. And more than anything else, terminology gives students a hard time, and the terminology doesn't lend itself well to understanding. Certain things you just have to memorize. And there's not a lot to memorize in this class, but we want you to memorize these terms. Okay, so where did I finish last time? Here-ish. Oh, okay, yeah, I was gonna call him. Okay, he's out. Chase, sorry, you're first, man. Okay, so Chase, let's start very basic. So the umbrella term that describes the entire topic is servitude. What's a servitude? Servitude. What's a servitude?
It's a burdening. It burdens a parcel of land.
Yeah, exactly right. The broad umbrella of everything we're doing here is called a servitude. It's effectively an arrangement that burdens one parcel of land, right? Benefit another. In property 1, you guys study future interests, and those are various forms of burdening land. We are not talking about those here. We're using a more modern invention, which are called servitudes. And we described 2 different species of the servitude. There was the easement and the covenant. We'll do covenants next. That's the next topic we'll do. But the first topic we have is the easement. Okay. And we have 2 different types of easement we discussed. These are easement appurtenant and the easement in gross. Okay. Let's see, Tyler, what's the difference between the easement appurtenant and the easement in gross?
The appurtenant is the benefit goes to whoever owns the land.
Good.
And then for the gross, it's specific. It's a specific person.
Good.
It's a name.
Okay. So the question with the easement is, again, who is it benefiting? And there are different ways of assigning the benefit. An easement in gross, right, assigns the benefit to a named person. And sorry to pick on you again, Dominique, we give it to Dominique, right? And no matter where Dominique lives, no matter where she moves, no matter what land she owns, she can still benefit from that easement. In contrast, the easement appurtenant, the benefit belongs to whoever owns a parcel. So if we say the easement in appurtenant goes to the owner of Blackacre, whoever happens to own Blackacre gets the benefit of the easement. Okay, don't get those confused. Again, memorize those words. There are not too many of them. This is not that complex. We also have other terminology: dominant, tenement, and servient tenement. Okay. Will, what's the difference between the dominant tenement and the servient tenement?
The dominant tenement is the land that's benefited, while the serving tenement is the land that's burdened.
Perfect. Yeah. The dominant tenement is a land that is benefited, and the serving tenement is a land that is burdened. Okay. These terms are important because if we have an easement that says, I can bring my chickens onto, the owner of Blackacre can bring his chickens onto Whiteacre, whatever it is, right? Whiteacre is being burdened, that is servient, and then Blackacre is dominant, that's being benefited. Like on the exam, right, you will need to use these words. If you tell me the land that is benefited, I don't know if you know what dominant and servient are. If you use the word dominant, okay, now I know that you have the correct terminology. So try to get those terminology down pat. Yes, ma'am.
Do you care if they use dominant tenement or dominant estate?
I don't care. Estate and tenement are synonyms. Synonyms are the same thing. I don't care. Okay, and the last phrase I want you to learn about, Omar, bring it home, is a license. What's a license? How is it granted?
It's for the use of the land.
Does it comply with the statute of frauds?
I don't think it has to.
Why not? What about it makes it not comply with the statute of frauds? Bingo. A license is an oral promise, right, to use land, oral permission to use property. This is, I tell you, Omar, okay, Omar, you can go across my road every single day. I don't care. You can use it, right? But Omar, can I revoke that? Yeah. Because it's not subject to the statute of frauds, right? Because it's oral, I can revoke it any time and there's no penalty. We did a couple cases on Monday where the facts were that people had detrimentally relied on it. You had invested money, you had improved the road. There, the courts hold that licenses are not revocable. But that's the exception. For the most part, licenses are purely revocable at any time. Okay. Any questions in those terms? Okay, have the way so you can see them. Yeah, again, the hardest part of this topic is getting your terminology down. Go back, reread those after class, get to know them, and you'll have it down pat. When we go into covenants or a bunch of other terms you have to learn, but for now, these will help you. Okay, any questions on that? Okay, let's move on. So, Evan, I won't forget you this time. I'm always jumping to that corner, hit him up first. So go, Evan, let me ask you this question, right? We discussed a couple different ways of creating an easement, right? But in every case, the easement was written down by the parties, okay? Is it possible for an easement to be created not by the parties, but by a court?
Yes.
Okay, that's right. Under what circumstances can a court create an easement?
Easement by necessity.
Good. Yeah, exactly. Yeah. So these are called implied easements, right? Implied easements. Jimena, what does the word implied mean? It's used in every class you'll probably ever take. No. Implied and inferred do not mean the same thing. People always get this confused. I'm picking on you, right? If I'm implying something, I am suggesting something. If you infer, you are listening to me and making a judgment based on it. I imply, you infer. They're not the same thing. But generally speaking, who does the implication? Who does the implying in these sort of cases? When there's an implied easement, who's doing the implying?
The person that
Can a person by himself imply an easement that was never written down?
yes,
How?
by being in a prescriptive right.
And who pronounces that easement? Bingo. Okay. That's the answer I'm looking for. Implied easements aren't from people. If the people reach that arrangement, it will be expressed. It will be written down. An implied easement is a judgment by a court that based on certain factors of fairness or whatever else, there ought to be an easement. There should be an easement. Everybody understand that? Yes, sir.
We call it express.
Well, yeah, I mean, if you and I make an arrangement, right? That's an express easement. We've written it down. It complies with the statute of frauds, no problem. But in case of necessity, we'll do in a couple minutes, it's a court that's implying, saying, well, you know, you didn't reach an arrangement, but I'm going to treat it as if you did. I'm going to imply an easement where none was expressly granted. Yes, sir.
I drive across your land every day, but you never say I can, you never say I can't. Is that also implied?
Well, prescription is a type of implied easement, right? The reason why it's implied is that we never worked anything out, but a court some years later may say, well, because of your prescription, you've used it for every day with adversity, then you actually get your easement. So the entire thrust of this topic is how are courts creating easements when the parties do not agree to one? Everyone see that? So, Michelle, what's the cost, though, when a court implies an easement? What's the cost there?
One party is burdened by having to pay for that someone using that land and others without.
Yeah, exactly. Your fee's simple, right? Your bundle of sticks just got a little bit smaller. You used to be able to exclude whoever you wanted. But when the court implies an easement, you can no longer have the right to exclude. Okay? And specifically, the value of your land is diminished, right? How is the value of your land diminished? Michelle, what happens if you want to resell the property? What happens to your resale value? Why?
Because you don't have free use of all of them. Someone else has the right to use them.
That's exactly right. While you could have charged a lot more money before, now you're burdened by that implied easement, right? And use the example last week. Imagine Rockefeller Center, right? Had an easement on it for the public to cross, right? You just lost billions of dollars in real estate because now you have to deal with this, you know, the people, you know, whoever crossing across your land. So it's very easy in this case. I don't want you to get carried away with fairness, right? But whenever the court implies an easement by necessity or implies an easement by prescription, someone's property value just got a lot lower. And when we discuss the idea of whether it's necessary to have the easement or strictly necessary, you say, oh my God, that's not fair, right? Well, think about the other guy. Think about the person whose property value was just diminished. And that's why courts take varying approaches to how necessary and indeed proper, I suppose, the easement must be. Any questions on that? No? All right, let's start off with the first case. Ethan, oh, we have a Texas case, right? Ethan versus Rosier. And actually, not that anyone cares, but this is Justice Brewer, who sat in the Supreme Court in the 50s. So this case is actually from, I don't know if anyone from here from Cedar Hill, Texas. Anyone know where that is? I randomly Googled, what was it? Beltline Road and Duncanville Road, and I found there was only one place in Texas that intersected, so I'm guessing it's Cedarville, Texas. So let's go to Stephen. Stephen, let's walk through the 4 transactions, and this is a diagram similar to the one in your book, but a little more colorful. There were 4 transactions that happened on the slot, and let's walk through them, please, one by one. And I want to be very precise with who sold what to whom. Please.
The first one, Bill sold the 100-acre tract in August of 1897.
Okay.
To the Rosier.
Good. Yeah. And in case you're not sure, Rosier, 100 acres, 1896. That's why I like this diagram because it explains it very clearly. Okay. That was the first transaction. Okay. So I'm going to stop you there. I'll move on to Caitlin in a second. So at the time, right, that Rosier purchased this lot, did Rosier have any difficulty getting to the road?
I don't think so.
No. And here, I found a satellite image of it as well. The lot looks virtually identical. It's basically this huge, massive square. This is the main drag, the Beltline Road, and this is the Duncanville Road. They actually tore down all the property some years ago because of some drainage issues, right? But when the first transaction was made in 1896, Rosier lived there, put his house there. He had no difficulty moving onto the road, right? Okay, so far so good. Caitlin, so I said, question? I heard. Yes, so the phrase is mezzanine conveyance, right? There was an intermediary, but we don't really care about him because Rosier steps into his shoes. Yeah, so you're right. Rosier didn't come to the picture until 1924, but the person who brought it in between did buy it then, and whatever interest that person had, Rosier steps into their shoes. That makes sense? Yeah, I'm summarizing because I don't really care about the middle guy, but you're exactly right. All right, Caitlin, what was the second transaction that transpired?
Hill conveyed a 60-acre tract in 1897 he conveyed a 60-acre tract.
Good. To whom?
To, did he convey that Othen?
Yeah,
Okay.
you're right. Yeah. Good.
Oh, yeah.
Okay, so when Hill conveyed this 60-acre tract, right, to Othen, did Othen have a pathway to the main road? Could he get to the main road?
I think so, yeah.
Okay, what was the pathway to the main road at that point?
It was where the 1899, yeah, that box.
Okay, so this is this yellow line, right? This is this this passageway. Now, is there any indication, Caitlin, that Mr. Hill, who crossing over this road? Okay, so again, when Hill sold this bit to Rosier, right? Rosier was not locking himself in. There was a path which allowed him to cross and make it to the main road. Okay, thank you, Caitlin. Alex, what was the third transaction that happened here?
Hill conveyed 3-acre tract and 16.31 acre tract.
Oh, yeah, okay, good. So the third one was the conveyance of this 53 acres over here to Othen, okay? Now, Othen owned this one, Othen owned this one, right? Did he have any difficulty making his way to the main road? Right, because he still uses this little yellow path, right? Okay, good. Norma, what was the final relevant transaction that we have here? Yeah, what was the final piece of land that was sold in 1899? I'm sorry? Yeah, the 16-acre one right here, okay? Hill sold the 16-acre lot to Rosier. Now, Norma, at this point, did Othen's exit become more difficult? I'm sorry, say that. I can't hear you. Speak louder, please. Well, it was Hill, and Hill had no problem. But who now owned this 16-acre lot that was blocking his path? Okay, so I'll ask you the question again. Did it now become, more difficult for Rosier to get to the road? Yes, it became more difficult. So the issue becomes this, Dominique. Norma said it was more difficult, which is correct. Was it impossible Was it impossible for Mr. Othen to make it to the road? It was not impossible. That's right. Why was it not impossible? Before it flooded, logistically speaking, is there other ways for Othen to access the main road? Really? There's no other way? Look at the map. Is there no other way for Mr. Othen to get to the main road? And then where can he go? Yeah. He can go north or he can go south. So under this doctrine of necessity, right, the most convenient route is from just cut right across here. That's the most convenient route. Think back to von Valkenburg. Remember we crossed over the yard. But you can go like this, or you can go like this, right? Josh, does it matter that he would have to then buy an easement from Hill on the top or bottom? Why doesn't it matter? Yes, and that's the rule in Texas, right? In order to try to get an easement implied by a court, you have to show that it's strictly and absolutely necessary for the court to diminish the value of Rosier. Because effectively what he's asking for is to take Rosier's property value and chop off a piece of it and give you a permanent easement that lasts basically forever. When you could buy an easement to go around this way, or even maybe go this way, right? The court wasn't clear if there were other roads available, but presumably there were other roads that you could actually take, right? Some questions on that. So, Sam, what happened then when the road flooded, and what's his face, Rosier basically just let the road go?
When it flooded, the diversion got so much.
Yeah, Othen, yep. Yeah. Yeah. So I think this case is a good illustration. In fact, one from straight home in Texas, that you need to. There's no other way that you can possibly get to the main road. And this rule, I think has some logical appeal to it, because whenever you imply an easement, you're basically taking the property value of Mr. Othen and you're diminishing it. I'm sorry, Rosier, you're diminishing it. Make sense? Okay. Now, the more important question, which I think is taught better with the diagram that we have over here, is about reserving easements. So if you go to question number 2, it comes after the case. I don't know if it was a page number, just call it out. Do you see it, Mike? What page?
840.
840, yeah. Okay, page 840. So, Mike, go ahead and just start reading that question, please, and we'll refer to the diagram up here. The question number 2. Yeah, right by the diagram.
There is some conflict in the cases of a degree of necessity required for easement by necessity. The transitional and still boundary review.
No, hold on. I think we're talking about different things. No, you see the diagram? Yeah, the question by the diagram. With A, B, C, D, E, F. You got that?
A owns 5 adjoining tracts of 4 sides.
Okay, yeah, that's it. Thank you. I think the page was switched in the last edition, which is why I might be off by a point, so I apologize for that. So we have here a situation, right? We have these 5 lots. All right, so go and please read.
A owns 5 adjoining tracts of 4 sides. Numbers 1 through 5.
Okay, so I stopped right there, right? A owns all 5. He owns 1, 2, 3, 4, 5. Mike, does it matter that number 5 is locked? It's landlocked. You can't get out. Does that even matter?
Yeah.
Exactly. When you own fee simple for the entirety of the lot, it makes no difference whether you're locked, because you can trespass on your own land, right? There's no there's no prohibition of trespassing in your own land. Okay? All right, Mike, read the next sentence.
All 5 lots have previously been owned by O as a single tract. A purchased each lot from O in separate transactions.
Okay, good.
Lot 1 first, lot 2 second, lot 3 third, lot 4 fourth, and finally lot 5. So,
Okay, so let's go this one step at a time, right? You buy them in sequential order. All right, Mike, when you bought lot number 1, was there any problem? Okay. When you bought lot number 2, was there any problem? When you bought lot 3, was there any problem? When you bought lot 4, was there any problem? Okay, when does the problem arise?
when you get that tract of land, that's
When he buys lot 5, right? Now, in the facts we just discussed, the same guy had purchased everything around it, right? So when they acquired lot 5, what do we generally assume was done? What should we assume happened?
there's some sort of easement to one of the other lots.
Exactly right. Here's the somewhat counterintuitive issue. We presume that no one would ever buy a piece of landlocked land. Even if they themselves can walk across, presumably at some point they will sell lot number 5. And if they sell lot number 5 to someone, they will always sell it with an easement to cross something else. So what we actually say is that when lot 5 was acquired, right? When lot 5 was acquired, an easement was reserved to cross, I don't know, any of the 4. It could be any of them. Make it lot 4 to make it the easiest one because it's the most recent in time. We presume that no one will be stupid enough to landlock themselves in the middle. And they presume that no one will be stupid enough to sell it to someone else that's landlocked. In fact, that's probably not even a marketable title. If you think back to what we did a couple weeks ago, sell somebody a landlocked piece of property because you can't get there without trespassing, right? It's impossible. So you presume that an easement's actually reserved. Okay. All right, so Ryan, keep going with the question, please. You saw it's on page 843? 841, thank you. So keep reading the question.
Lots 1 and 2 are bounded by a public road to the north, lots 3 and 4 are bounded by a public road to the south, lot 5 has no access to the public road except through one vehicle.
Okay, keep going.
A has intestate, 5 children, B, C, D, E, and F are heirs, and the degree of distribution settling A's estate, the court assigns lot 1 to B, 2 to C, 3 to D, 4 to E, and 5 to F.
Oh, poor F is F, right? Yeah. Why is F in trouble? Okay, now, F sues, right? Owners 1 through 4. What does the court do here?
Well, this doesn't fit into some of the other examples you're reading afterwards, so they have to present easement across one of the properties.
Exactly. Yeah, so what happens is once F inherits the lot number 5, he would have to sue for an easement by necessity. And a court would have to then determine which lot gives up the easement. So Ryan, how do you think they go about determining which lot gives it up?
They would probably figure out there were any roads,
Good, yeah.
and then just go with the easiest path, and if there wasn't one, then they would have to go.
Yeah, exactly right. And I think the shorter answer is they pick the one that costs the least money, right? Whichever is the cheapest property, whichever one will be diminished in the least value, equity kicks in. And the court would actually pick the one which has the smallest burden on other parties. Yes, sir.
In a case where they're all equal, essentially, how do they make
Flip
it
a coin.
equal?
I don't know. Pick the least favorite child. I mean, this is a beautiful example. We have 5 perfectly sized lots, right? But generally, it'll look more like, you know, like this case, right, where the lots are all different sizes, and you know, there's roads here, and that this road got flooded. So at this point, a court has to go into equity because ultimately, once you cut a chunk out of lot 4 or 3 or 2 or 1, that property has just been diminished value. Right?
There was a case in here they were talking about where there was a guy who had a lot on the cliff.
Oh yeah,
And they were
yeah.
like, yeah, building a road would cost $700,000 if we don't care.
Isn't that crazy, huh?
And specifically in that case, they were talking about how it was voluntary. If that was involuntary, if I was on a cliff. I mean, in that case, it's not voluntary. It's
This case is an inheritance, right? So it's probably a little bit of a difference. But to your question, right? The question was this: What if someone buys a house on a cliff? And let's say there's like a landslide, and the only way to get to the road is by trespassing someone's property, right? Well, idiot, you bought a house on a cliff, and one of the inherent risks of buying a house on a cliff is that there might be a landslide. The other example is what happens if the only way to get across, the only way to get to the main road is by boat, or you can trespass. Court says, okay, use a boat, go ride a boat. It's very fact specific in these strict jurisdictions. They don't play around here. If there's a way, use a helicopter. I don't know. Is that reasonable? But they definitely said you can use a boat instead of using a car. Now, these easements by necessity, Cameron, how long do they last for?
As long as they're necessary.
As long as they're necessary. How long in this case, go back to our boxes, how long will easement by necessity be necessary here?
Probably a pretty long time, unless, the guy only bought, or I guess until F managed to buy some of the property in one of the other lots. Or
Yeah.
actually buy a permanent piece of land through it.
Pretty much forever, right? Unless a different road is cut or there's some way out, the easements by necessity last forever. But generally speaking, when you have an implied easement by a court, it lasts only so long as it's necessary, right? So it's not indefinite, but in a case like this, it probably does last for nearly forever.
So even if the owner of lot 5 bought one of the other lots where the easement was, then that easement would still be there even if he hadn't.
Say a question again, please.
Like, let's say the easement, they decided to go through 4 to get to the public road. If the person who owns 5 buys lot 4.
Oh, okay, perfect. So what happens if 4 and 5 have the same unity of ownership? What happens then?
I'd assume the easement is still there in case he
No.
sells.
Once you have the unity of ownership, easement dissolves. It lasts only as long as necessary. So if 4 and 5 have the same person owning it, the easement dissolves.
But if he sells lot 4 again,
Then it returns, right? So that's the funny part. If he sells to a third person, the easement basically you have to go back to court, but the court would infer it again. Apply again. I'm sorry?
Would it come back if he voluntarily sold 4 and left himself in 5? And if he didn't reserve it in the deed, if he was the one selling it, he voluntarily landlocked himself.
So this is the question, what do you do with the idiot, right? Someone who, in this case, I guess if he knew there was an easement implied and he bought it anyway, knowing that there had not been a reservation, he would have to hope a court bails him out. Maybe a court out of fairness, like, well, maybe he didn't understand the situation, or maybe because they were the same owner so long, he didn't realize it was actually landlocked. But you're technically right that under a strict necessity doctrine, he may be the fool of having a piece of land. I think what would happen in that case, though, is that the title would be unmarketable if there indeed was no access. And you could probably sue the seller for selling a worthless piece of land.
Is this a majority thing, or is this like half of them are going?
No, I think most states have the strict necessity. It's a very difficult standard to meet because you're basically diminishing the value of your property. I mean, some states have just necessary if it's convenient. Yes, sir.
You said that unity of ownership, there's no easements involved, but can you use pre-existing trails, paths, etc., to argue for an easement?
What do you mean?
Well, for example, I'll give you a real life example. Suppose 5 is a cattle pasture, and routinely from 4 to 5, they would drive cattle to a trailer and then haul them off the market. So it's a well-established cattle trail.
Yeah, but isn't that prescription?
Well, but if it was the same owner before, but then upon inheritance, 4 gets it, and then 5 is a separate inheritor. So can 5 argue that there's an easement based on the
right? So I didn't really discuss this because they're rare, but these things called quasi easements, right, where it's based on past usage.
Okay.
And these are pretty rare. But I think that they mentioned it very briefly being, and it's called a quasi easement implied from prior use.
Okay.
Where even if you don't have prescription, right, you don't have adverse possession, but if you use the cattle with permission every day for 25 years, a court may actually imply an easement based on prior use. Those are very difficult to get to because it's even worse than necessity. Now it's not just necessity, but it helps your business, and that's a very loose standard. Hand up there. Any other questions on this? Yes, sir.
Sure, matters. Just curious if the court you had a easement from 5 and you guys cut across the board. Who would have to pay for the road?
Okay. That was actually my next question, right? Let's go back to who we have to. Kaylor, when you get an easement by necessity, is it free?
Yes.
Is it free to the person who benefits?
Yes.
No. Why not? What do you think? Why do you think the court would not make it free when they give an easement by necessity? Yeah. So effectively what the court does is a forced sale, if you think about it. The court basically forces the landowner, number 4, to sell an easement. They don't have a choice, because usually you have a choice. Do I make an easement? Do I not? The court forces the sale. What do they charge? Fair market value. I'm not sure how they arrive at the rate. Probably a lot less than the person wanted. Why? Because if number 4 wanted to sell the easement, he would have sold it. The fact that he didn't sell it means he didn't want to sell it. And whatever price the court orders is no doubt too low. So, yes, ma'am.
Does that apply to both easements by necessity and prescription?
Oh, I was going to get to prescription in a minute. But yes, the answer is the same. If the court forces an easement by prescription, you got to pay for it. You're not getting this for free, right? You just got this massive, valuable easement. You're going to pay something for it. Probably not as much as the seller wanted, but something.
So when these energy companies come in and like they'll put phone lines just straight across someone's ranch, do they automatically get an easement to manage and service those? So
utility companies are very specific. Under Texas law, there's a lot of case law on this. So pipeline managers and utilities are considered common carriers, right? And effectively, they can use what's called eminent domain. We'll discuss this later this semester. So if I want to build the Keystone Pipeline, for example, had a lot of case law on this in Texas. If I'm Keystone and I want to build a pipeline going across your ranch, I can negotiate with you. And if you tell me to get off my goddamn ranch, I can then come back with the state and say, okay, we're going to condemn your land through a court proceeding. And that's effectively what's called eminent domain or condemnation. And you have to pay a rate that's effectively set by a court, and there's all these procedures to set the rate. But there were massive fights by Texas landowners against the construction of these pipelines, and the courts consistently ruled against the homeowners.
Well, they don't get attorney's fees, so it's still worth the fight.
Are you speaking from experience?
Yeah, screw them.
Tell them. Oh, you've had this experience?
We have a pipeline going right through the middle of our land.
No. Now, did they try? Who made it? Keystone?
No, it's old pipeline, and we actually have power lines too. Going
Did anyone try to negotiate with you? Or they just came in and condemned it.
They can do it.
Yeah. So I mean, they're supposed to actually try and make you an offer, but the offer is usually so low and pitiful that you won't even entertain it. So then they have to go through a condemnation proceeding. So we'll discuss eminent domain later in the year. And while some aspects of eminent domain are controversial, such as when they take down your house to build a Pfizer facility, right? That's a Kilo case we'll study in about 4 or 5 weeks. That's controversial, but using eminent domain to build power lines, pipelines, roads, that's probably within the public use clause of the Constitution. That's probably a public use because people benefit from utility poles, they benefit from power lines, they benefit from the free flow of oil and gas. Make sense? Okay, let's go on to easement by prescription. So Paul, we discussed prescription a little bit last time, but how does easement by prescription work?
I think it's similar to adverse possession.
Yeah, exactly. When you say prescription, just think adverse possession. But what's the main difference, Paul, between prescription and adverse possession?
That instead of acquiring title of the land, you acquire the right to use the land.
Exactly. With adverse possession, you're trying to acquire title to the land itself, ownership of the land itself. With prescription, you're gaining, quite literally, an easement to cross across the land. Okay? And the classic example, you walk across a field every single day for 25 years. The owner says, get off my lawn, and you keep doing it anyway. It's adverse. It's against claim of right. You've now gained an easement if you go to court. Indeed, if you remember von Valkenburg versus Lutz, this was the very first case we did the first week of class. Remember he crossed over a land so he avoids the hilly road. Remember this? That was a prescriptive easement. Okay. Not too much more about that. There's a funny case mentioned in the book about hitting golf balls. If you keep hitting golf balls across someone's property, hit them, have you actually gained a prescriptive right to hit golf balls? And those cases are a little bit fishy. Okay. All right. Any other questions about easements by necessity, prescriptive easements, quasi easements, any of that stuff? Yes, ma'am.
I have some confusion about the relationship of the terminologies. So
The relationship of what?
relationship between the terminologies. So we know the expressed easement and the implied easement. So what's the relationship between the implied easement and the easement by necessity? It's included or it is
Yes.
parallel.
Yes. So implied easement is the umbrella, right? Implied easement is a category. Easement by necessity is the type of implied easement.
Okay, the easement by prescription is included.
Yes, ma'am.
Okay,
Yes, exactly right.
thank you.
Yeah, implied easement, this was the topic we began today. Implied easement basically means the easement wasn't reached by the parties. The easement is implied by the court. So an easement by prescription, an easement by necessity, the quasi easement. These are all different types of implied easements. Now, if you and I reach an arrangement, we write it down, it satisfies the statute of frauds, that's an express easement.
So what about the easement by reservation?
That's also implied.
Implied and parallel to the easement by necessity.
Yes, ma'am.
Okay.
Understood? Okay, very good. Other questions? Anything else in the implied easements? Again, the only thing you really need to remember is with respect to strict necessity, Texas courts in particular are awfully strict. And unless you have to fly a rocket ship to get to the plant, you're probably not going to get an easement. Anything else?
Could you repeat the types of implied easements?
Sure.
Or those that we need to know?
Yeah, sure. I'd be happy to. And I'll do one better. Actually, I'll type them so you can actually read. So in terms of implied easements, there are a few. So there's easement by necessity, by prescription. You have the quasi easements. What was the other one you said? You said the last one. Yeah, that was it. Easement by reservation. I mean, these are basically all easements that are implied by a court, and they're not written by the parties. In other words, they're forced sales. You're forcing someone to give up an easement based on one of these doctrines. All the doctrines basically have the same attributes of fairness. Make sense? Any questions? All right, ready? Let's go to the Jersey Shore, okay? Serious? So we have a significant number of cases involving beaches. And this is actually an entire area and doctrine of the law. Okay? What's it up to? Jessica, why is beaches and the water considered such a specific and varied exception to the law? Why are beaches so special? Yeah. So generally speaking, and this goes all the way back to Roman law, the water belonged to the public, right? You can't stop someone from going to the water, whether they're fishermen, whether they're navigators, right? The water is open to the public, okay? But there's a problem. Even if the water is open to the public, getting to the water is not so easy. And this is a diagram of a beach. I think this is in Malibu, California, but this is your typical beach, right? You have your road, you have your private property with vegetation, you have what's called the dry sand, you have what's called the wet sand, and then you have the water. Okay? Haley, why do you think it's so difficult to mark property lines along the shore of an ocean? What makes the attributes of water so difficult to mark property lines? Yeah, what do you mean it changes? Yeah. I mean, it's based on the lunar cycle, right? When the high tide comes in, right, you have the water all the way out, and then when the low tide comes in, the water comes all the way in, right? At different times of the month, the water line can be all the way up here, can be here, can be here, can be here. Okay? We know the water is public property, and we know where what's called the vegetation line, right? Basically, if you go to a beach, when you start seeing plants start growing, that's an important point because that means it's the vegetation line. There's often enough not water flowing there that plants can actually grow. So here you can kind of see grass and other stuff, right? There's no water there. The in-between stuff, though, is tricky. So traditionally, the dry sand, where there's usually dry sand, you can see here it's, it's like a different color. The dry sand traditionally belongs to the property owner. So if the guy's house is over here, he owns the dry sand. The wet sand, which you see this, this region over here, that belongs to the public, what's called the public trust, if you will. The government holds it in trust for the people. Okay. But this creates another difficulty, right? So we all agree, no problem, that the public can get to the water, the public can get to the wet sand, but how, Ravashi, is the public supposed to get from the street to the water and the wet sand? You mean trespass along this guy's oceanfront property? Is that what you're getting at? Oh, ask them. Yeah, I'm sure Malibu, they'll love you to cross their property, right? Yeah, it's like a Barbara Streisand list. Right? I'm sure she'll just love to have you guys traipsing around her property. What do you think? What do you think the law has done to make beach going practical?
It's not been said that you can't block access. You have to.
Okay, good. So one of the doctrines developed is what's called lateral access. So you can't really see, if you see these dotted green lines, you kind of make it out there. There's a path that goes from the street down to the water. As a matter of law, people who own beachfront property are obligated to give up what's called this lateral path to allow people to cross from the street onto the wet sand. Okay, and the reason I think the property rights heart breaks, but if indeed there's access to water and the water is a public trust, people have to get there somehow, right? They can't just like hop over the house. They can't like a pole vault or something, right? So, and this is especially true with our public beaches, where you have an entire stretch that's all private property, which is close to the facts of the New Jersey case we have in a few moments, where basically the entirety, you can't see too well, but the entirety of the white sand beach has private homes right in the water, which is not surprising. Usually beachfront property tends to be expensive and exclusive, right? So we start with the premise that you have access to the water, you have access to the wet sand, and you can walk from the street to the wet sand. Everyone with me so far, right? But what about hanging out on the dry sand? What do you think, Rachel? Is hanging out on the dry sand necessary to avail yourself of the public water?
Well, it's a public right.
Oh, no, but is it the water's public? Why do you have to hang out on the dry sand? Go swim, then walk along the path and go back home. What's the problem? What
Depends what part.
what are you supposed to do in the what's necessary to do in the dry sand? So, quote the New Jersey Supreme Court. The public trust doctrine protects, quote, the right to sunbathe, tan, and enjoy recreational activities. Yes, you are exactly right. This is my favorite New Jersey Shore meme. I was a huge fan of the show. Every year this meme gets less funnier, but I will still show it. By the way, who knows why there are only 7 people there? Ooh, this is a trick question. But 8, right? Why only 7?
So they won't perfectly pair off.
Well, who knows? Who knows? None of you. Oh, so you break my heart. I grew up in Staten Island, which was effectively New Jersey. And he was from New Jersey, and he went to school in Jersey also. So Angelina was one of the cast members, but she left the show because she was a brat, and that's why there are only 7, but they got a replacement eventually. Now you know. But the rationale holds true. What the New Jersey courts effectively said is, it's not enough to give you access to the water or the wet sand. You need to tan. You need to sunbathe and dry off, right? But the result of this, and this is what this case demonstrates in part, is that entire swaths of beachfront property are no longer private. There was another case, which is in your book, but they edited it out, where you had a private beach club. And the beach club said, okay, we'll just keep our own equipment on the dry sand and we'll charge a membership fee. And the Jersey Supreme Court said, no, you can't do that. You can't charge a membership fee to the public to go onto the dry sand. So in New Jersey now, basically any beach you want, you can go onto, right? Well, let's go through the facts of this case, Matthews versus Bayhead Improvement Association, right? Aaron, walk us through what was the dispute here? What was the problem with this?
The Bayhead Improvement Association
Okay.
was a quasi-public entity.
Okay.
And they own portions of the beach in Bayhead
Mhm.
and a town on the shore of the Atlantic Ocean.
Good.
And only associated.
By the way, everyone know what a borough is? Yeah, the word borough refers to like a town or municipality. It's a common phrase used in New York and New Jersey. I don't think that word's used here. So a borough is not like what a gopher does, right? A borough is like a town. For example, I lived in Staten Island, one of the 5 boroughs of New York City. Brooklyn, Queens, Manhattan, and the Bronx were the other ones. Learn something. All right, Aaron, keep going.
The only association members were allowed to use portions of the beach during certain times of the
Basically, so not these guys.
Yeah.
I mean, so let's be frank here. They were trying to keep these guys off the beach. I'm not actually being sarcastic. They were trying to make this an upscale beach resort and not like Seaside Heights. All right. What's that? Horribly, no. It's very trashy, very trashy. So, Aaron, you have no idea. So, what was the suit?
The suit was the public wanted to have use of the beach, and they would only allow residents to become members of their association to have access.
Okay, very good. All right, so Jeffrey, what did the court do here? Was this a legitimate use of the public trust doctrine?
Yeah, I think they're talking about something where up to so many feet of the wet sand, they would get access to that.
Yeah. So could this association exclude people who lived outside in an adjoining town from this membership? No. Yeah. Why could they not exclude them?
I mean, that would limit their access to the public space.
Yeah. And actually, the important insight is, I'm not actually trying to joke. If you take a very strict approach, that you have access to the water, you don't need to tan. But the court effectively said, as a matter of law in New Jersey, tanning is part of swimming. It's part of the beach-going experience. This is not just my own entertainment, although it is, right? It's actually part of the beach-going experience. And indeed, you need to have access to the water, and then you need to dry off afterwards and get bronzed, right? So they say basically the right to swim depends on the right to pass along the beach. Without access to the beach, this public access or this public right is meaningless. Okay? Any questions on that part? So Nali, does it matter that this association is private, kind of public? Does that matter at all?
No.
No. Why does it not matter to the New Jersey Supreme Court whether this is public or private property?
because public doctrine, on the public doctrine, it is open to someone. If it's open to someone, it should be open to the public.
Yeah, that's exactly right. Effectively, because the public trust doctrine treats anything that water touches, unlike these guys, anything that water touches as public property, then it doesn't matter if there's private land nearby. In other words, you chose to live near a beach, tough luck, deal with it. Now, again, this is a New Jersey Supreme Court, and as we've discussed more times I can count, their entire mission is to overturn various common law rules and weaken property rights. They're very good at that. And towards the end, they said that the advocate, this public advocate, urges that all property must be open to the public. We don't need to decide this, right? What do you think they did 20 years later? They decided it and said basically all private property near a beach must be opened up. So effectively, if you have beachfront property in New Jersey, if you have a private exclusive beach club, you have to let these guys in. And not only that, you can't charge a high premium to keep them out. The rates are actually set by the state. So effectively, you can no longer have an exclusive beach club. Okay? Yes, sir.
So like a set amount of like private of the beach, you can open up to the beach, but you can have like a little private.
No, no longer.
So
and in fact,
starts, it has to.
Yeah, and I'll give you one better. You have to pay for their lifeguards. Not only do you have to let them in at a low rate, you have to pay for their lifeguards. You have to clean the beach. You have to let them use your equipment, like the whatever chairs or umbrellas. You effectively can no longer have a private beach club in New Jersey.
Doesn't that take away any incentive to either be a private beach club? Or
Oh yeah. So there was a case, again, it was in the older edition of the textbook, but they removed it. We had a private beach club saying, like, we're going to go out of business. We're just going to shut down rather than having these guys run around our beach club. And I think, indeed, if you ever saw the episode of South Park, that's what happens with the Jersey Shore invasion. It's unavoidable. Hey, Ryan.
You're just saying that the state sets rates that they can charge?
There's like a state public commission that sets the rates what they can charge, yeah.
But if they can't have private beaches, why are you charging?
The fees are used to defray the cost of lifeguards and stuff.
But who's paying that if they can't keep you off the beach anyways?
No.
You can go without paying.
No. So for these, okay, there are public beaches in New Jersey, right? And those cost nothing to enter. There are beach clubs, which are basically adjoining property, but they can only charge a very small amount to defray the costs, right? So it's not that they can let you onto any beach indefinitely, but if you do have private property, they can only charge a very small amount. And I looked up, it's like $100 for the entire season. It's a pretty small amount if you consider what they used to charge, like hundreds of dollars a month, right? They don't have to let you into the actual facilities, like the house and the beach and the bar and whatever else, but the actual beach itself is open to the public. Yeah.
Why? What's the policy for destroying private property rights?
It's a Jersey thing. You wouldn't understand. No, I'm serious. I mean, the New Jersey Supreme Court has expanded, and they talk about the public trust doctrine. They say that it's not a static thing. It can expand to whatever the needs of society are. Basically, the judges of the New Jersey Supreme Court have concluded that access to the beach at all costs is very important, and private property rights are not. We'll do a case from the New Jersey Supreme Court in about 2 or 3 weeks called Mount Laurel. And this is a decision involving what's called exclusionary zoning, where basically a city makes it that the only house you can build is a one-family home. You can't build any sort of affordable apartment buildings. As a result, various minorities can't find houses. And the New Jersey Supreme Court basically said that every town in New Jersey has a duty to build inclusive housing, even if there are no minorities living there. That they have to basically consider jurisdictions as far as Camden, New Jersey, and even into Pennsylvania that may want to live in New Jersey. I will do this case in about a month. Yes, ma'am.
Was it in Mount Laurel?
This is where the case began, yeah.
I grew up in Mount Laurel.
Oh, no way.
The township. I think there might. Do you remember the name of the apartment complex that was that issue?
I don't, but I'm sure I could find out.
Okay, I think I was living there when first was an issue. They were building low income
Oh, interesting.
One story homes and a lot of people in the area.
Oh, good. Can you ask, does your mom or dad live there, or can you ask about this? See if they know anything about the case, because the Mount Laurel case, it's actually not just one decision. They're like 3 or 4, and it's been going on since the 1970s. It's been going on forever. And I mean, you guys will do this in a couple weeks, but Mount Laurel and other towns basically were kicking and screaming, trying to fight this because they didn't want to build the housing. And at every juncture, the New Jersey Supreme Court said, okay, you're not doing this right, so we're going to supervise you and hold your hand, build this here, build that there. I mean, it was a serious, one of the most furthest reaching judicial oversights of housing law in American history. And with all respect, I don't hold this up as an exemplar of good law because I think the court overstepped its bounds in many respects. But if you ask your parents about this, they may know some of the backstory, which would be interesting. Please do. We'll do this case probably the latter half of the semester, but if you can find anything, I'd appreciate it. Was that? Yeah. It's cool. We have at least 2 people from New Jersey in the room. All right. Any questions on this case? Any question? Anything else? Yes, sir.
If you go back to the picture where you said like Malibu type area, I understand the need to have like the access to the beach.
Oh, wrong one. That's
Why couldn't a state or a city do it like every third house? Or is it like a safety issue or just
so? So we'll do this topic also later when we do something called exactions. So what California, exactions do real estate, right? What California often did is they said, okay, you want to build a new house, right? You want to demolish the house, you want to build a new one. You have to basically dedicate an easement to the public. And basically California cajoled property owners to give up easements in exchange for zoning licenses. The Supreme Court said that was unconstitutional, which I think was a correct decision. But for many properties along Malibu, they've already reserved these easements to the public. Other questions? I have nothing else. Have a wonderful day. Good luck in the midterm on Monday. I will see you all on Wednesday.
Thank you.